Well, a very warm welcome back to the Andrew Eborn Show and my favourite episode of A Pair of Briefs when I'm joined yet again by Stephen Barrett. Steve Barrett, you prefer to be called Steve, don't you?
No, never. People have died for less, Andrew.
I realise that. It's funny. It's funny. People always, a name is so important. And unless you
It
pick them
is.
up
It
on it,
is.
it's so good.
Well, because I've sort of very lucky in that I've built my own family and I have close friends who are effectively brothers and sisters. And so what's quite odd is that nobody's allowed to call me Steve ever, except one of the women who is basically my sister has always called me Steve, and she's given a free pass. She's the only one who's allowed to. And what's quite interesting is the other one, when I first met her, just bumped into her on a bridge. I was with a girl and she was with her boyfriend, and she just pointed at me and I said, "Hi, I'm Stephen," and she just went, "No," and I just went, "What?" I said, "No, you're Sebastian." And she's just known me as Sebastian for her entire life. And I'm literally godfather to her daughter. So we had to have a conversation with her parents where they went, "Now, you know Sebastian." Yes. He's not actually called Sebastian.
Well, you look like a Sebastian.
Wow.
I love it. Well, I'm an
Anyway,
Andrew, not an
sorry.
Andy.
No.
So I, 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 I I think names are important. I'm definitely an Andrew, not an Andy. But I think what happens is people are so reluctant to change unless or to tell people they're getting it wrong. So it's good to call it out, isn't it?
Yeah, no, I think it's good to call it out. The most I've ever got is in court because everything's always handwritten. So the usher handwrites your name or you handwrite it for the usher. I used to get people know who I am now, but in the early days I used to get Mr. Bennett a lot because people would look at they'd write their R's like N's and the judge would just think it was Mr. Bennett. It's thank you for your submission, Mr. Bennett. And it's like I'm grateful.
Yes.
But yeah, so there's a lot in a name. Anyway.
All good, yes. What's in a name? Fantastic. We've been looking at the whole litigation process. I always pull up that wonderful Jay Bright cartoon, which shows litigation on the cow and the defendant pulling the tail of the cow, the plaintiff pulling the horns, but most importantly, the lawyers milking it. And the whole system, as we looked at last time, is geared towards people trying to reach a settlement, whether that's in the early stages of arbitration, if you like, or mediation, going to that sort of side, or actually the whole process, trying to encourage people, showing them how expensive it's going to be. We looked at that last time. We looked at the general side and we got to evidence. So we're still down. The litigation is still rumbling on. Talk us through that process because this can be the most expensive and tortuous side of the whole thing, can't it?
Yes, it really can. And barristers have little to do in it. And the judges keep fiddling with it because they hate it. They hate how ruinously expensive it is. What we should probably do is move to a US style system where you don't have something called disclosure effectively. But what we have is a duty on both sides to disclose, hence the name disclosure, to show, to give to the other side all documents, including ones that are harmful to your case. And law firms take it very seriously when they do a disclosure exercise, and largely they can make an awful lot of money out of one. So you'll often get people who have sort of paralegal jobs, and their entire job is to sit there in the disclosure room and make sure and document who comes in and who comes out, and which evidence comes in and which comes out. Now that costs an awful lot of money just to have somebody sat there, but because the law firms can bill for this, they quite like doing that disclosure, and it's getting all of your evidence into line. One of the reforms that came in, because I'm a child of something called the Wolf reforms. When I qualified, they just came in, so I don't know anything pre-Wolf. The entire system is basically based on the Wolf reforms. They've been meddled with a lot. Nothing has been more meddled with than something called Part 36, which has basically been changed so often that every time it comes up, I have to look at it again because I have a nightmare that it's changed and I won't know the rules. Who's just fiddled with constantly. Leave Part 36 alone. But he created all of these rules. Each rule is called a part, hence Part 36. And they have these. The biggest change from the old system was, as people know from the telly, or people expect from the telly, in crime, you go into the witness box and you give your evidence, what's called evidence in chief, but to your own barrister, and then you're cross-examined by the enemy barrister. In my world, and because I'm a child of the Wolf reforms, I have never known that. I was taught how to do it. So we had to do videos and practice, and I had to pass an exam saying that I was competent to do it. And I think I am competent to do it. In other jurisdictions where they do it, I quite like it. But we don't do that. And that's where this burden shifts to the solicitors. Instead, you have a witness statement. And your witness statement, that the point of the Wolf reforms was that evidence in chief was roughly 40% of a trial's length. And so he got rid of it at a click of a fingers by replacing it with witness statements that a judge could read in advance. Ergo, Harry Wolff has cut trial length by 40% of time, which is true. And that, to his credit, that's his greatest achievement, I think. And but that has made my life poorer. I mean, it's less fun. So you don't really do evidence in chief. I just stand up, person goes in the witness box and says, can you have a look at this document at page blah of the blah of the bundle? Is that your signature? Yes. Did you write this yourself? Yes. My lord, can this be his evidence in chief? Yes. Like, I'll sit down and no further questions. And it's all a bit boring for me, but it does save money. And but the knock-on effect is that all of this disclosure and the effort that goes into witness statements. Now, there was a spate of scandals starting in about 2014, where the judiciary got really, really angry at solicitors for how they were basically writing these witness statements. The witnesses would go in the box, and they'd be asked a question about it, a killer question that could change the trial, and they go, "Oh, I don't know, my solicitor wrote that. I don't know. I don't know. What do you mean by this? I have no idea. He wrote that." And it's just like, and that is a major problem. So they've kicked back and they've now brought in extra rules that you really must write it yourself. The net result is that I have even less to do with witness statements, because they used to sort of send them to barristers and say, have a look and say what you think. And now I'm like, no, because then it won't be him writing it or her writing it. I can't. So I have even less to do with witness statements. I read them before the trial, in the trial prep period, but and if there's something necessary for an interim hearing, but I'm generally not involved in that world anymore. The solicitors do it all, and they decide which documents get annexed to something. I mean, that's what I might get asked about nowadays: is should we exhibit this or should we not exhibit that? But
I think it's. I mean, it is more. I know it's the solicitors thing about disclosure, but if people are subject to litigation, they get down that unfortunate route. I mean, the obligation is very broad and covers all documents, doesn't it? Under the parties' control, which are relevant to the issue in dispute. There's also an obligation not to destroy anything, and so on and so forth. Talk to me about what's in and what's out. Is anything out, and what the penalties are if people don't comply?
Well, they can be quite severe. I mean, we are gliding towards an American style system. So I don't know how sustainable disclosure is. We had a disclosure trial, so trial and changing the way it all worked, and that's now been approved and gone through. So the penalties are lesser, the obsession is less there. You can argue that, and the Americans Americans get very upset, by the way. There's two things that really annoy American clients if they're litigating in the UK. One is disclosure, because it's like, this is costing a load of money. Why do I have to give him this document if it helps him? It doesn't help me. So why do I have to arm my enemy against me? Which is it's a fundamental moral question. It's just that's the view of our judiciary, that you should, because that's the morally right thing to do. Because that really, we're still a Christian nation, and that is what a Christian would do. And people sort of forget that, but it's true, and it's deeply embedded in lots of our systems. The other thing that really, really annoys Americans is that I can't do what they do over there, and people will have seen it on TV. I mean, it's even in Marvel, like Daredevil does it, and they practice with their lawyer before they give evidence.
Right.
And their lawyer gives them advice, and they sit and they prep them, and I ask them, questions that they might be asked, and the Americans do it, and they pay their lawyers for it, and they expect it as a service. And we have to go, if I did that, I'd be kicked out of being a barrister, so I can't do it. Because we call it coaching. We consider it a mortal sin.
Well,
So
it is coaching, isn't it, effectively?
Yeah, it is.
So you've got this sort of stuff, but how do people discover? And we've had lots of these cases, where, especially about WhatsApp messages, which seems to disappear, or phones that end up in Davy's locker. And where's Davy's locker, as they famously said in the Wagatha Christie's trial? I don't know, Davy. And the reality is that what are the penalties, and how do people, to what extent do they sort of follow through? How do they try and find out? Well, this evidence really existed, but it was destroyed.
Well, the penalty is really very simple. Because we don't have juries, the judge is in control of fact. One of the other reasons I talked last episode about is staying reasonable, but it's a very good idea to stay reasonable with the judge. Just remember, he or she is actually deciding everything, not just the law. They're deciding everything, and they will decide what is true and what is not true. They do it on the balance of probability, so that's quite a low standard. That's a 51-49% test. I did think during the Brexit nonsense, I mean, Jonathan Sumption got angry about it being 41, 51, 49. No, your entire professional life has been based on a 51-49% standard. I mean, it just, if there's anybody who can't complain, it's us. I mean, that's literally our life. Anyway, I'm neutral on Brexit, so I got to sort of see the funny side. But in terms of making that decision, the judge is fundamentally important. So the biggest penalty is that the judge won't believe you, because that is the absolute biggest penalty. So if one side is saying there were all these WhatsApp messages and now the phone's been thrown over into the sea, which I think that did happen. I know I don't want to talk about a real case, but
Oh,
imagine
no, it's certainly, well, it's been reported in a number of cases. It's a very famous. People sort of say they lose WhatsApp messages, or they change their phone, and therefore WhatsApp messages are lost. So it's a practical example of that, where you can see there's an obvious hole in the evidence, and it's only, you can talk about it. Agatha Christie, they had a particular case there where basically Rebecca Vardy said that she lost her phone, or it went overboard at sea, and the council said to her, in Davy's locker, and I think she basically said, "Well, I don't know who Davy is." So they worked on that sort of basis. But no, so it's disappearing. So the judge basically, so it's to do with credibility. That's the first thing. Are there any penalties though, apart from credibility? It's a big thing if they decide against you. Are there any penalties that the courts can impose if they believe that you haven't disclosed everything?
yeah, the most important penalty and the most important word that I learned when I trained to be a barrister rather than when I was qualified as an academic lawyer, if you like, after the academic stage. The word that dominates my professional life and has dominated it always is the word costs. And the judges have I mean, literally, the only the trite law is that the judges have wide discretion on costs. What that means, listeners, is that you're incurring legal fees all the time, and the other side are incurring them too. And if you win, you really want to get as much of you've paid your lawyers back. Now, sad news, you're probably only going to get about 70-65% back.
And
That's
why is
because
that? I mean, just for the benefit of those who turn around and say, well, that's very unfair. Somebody's brought a case against me. They lost it. They were wrong to bring the case. Why don't I get all my fees back?
I mean, it's easy to say because judges in the United Kingdom are all communist, but it's because I think if you give a man or a woman a power to interfere in the market, they will. Judges generally, I mean, this may shock viewers, but judges generally have a really low opinion of solicitors and not so much barristers, because like they know that I'm going around telling my client to settle and trying to do the best thing, but they probably, and they'll trust me that I'm doing that. They will look at me and go, he's an honourable, honest person. But they'll probably look to the person behind me, the solicitor, and go, not sure he's doing that. And they get very grumpy. And they also tend to have been a solicitor or a barrister themselves in practice. If they're a barrister, then they really have very little understanding of economics, so they'll just meddle all the time. Judges, get very arbitrary. They're like, this would have taken me 4 hours, therefore it should have taken you 4 hours. It didn't take you 6, which, I mean, that's one of the most nonsense ones. It's always irritated me. It's just how they are. The other theory is that British judges are so fair that they think that they've just punched the other side in the face, so they may as well punch you in the face too by reducing your costs a bit and making it not so bad for the other side. And litigation is ruinously expensive. I mean, that is that is the be all and end all of it. I mean,
Always Jay Bright rings in my ears every single time, and so it's a negotiating tool. We've looked at this whole sort of process. So you get your documents which are supplied. You get the factual witness statements now to speed up the whole process. Expert witnesses preparing for trial. Talk to me about how people should prepare for trial. What do they need to do?
well, I can't coach anyone, so they should have a good night's sleep and tell the truth. That's about all I can say. And we do believe in this. I mean, I would probably move to a more US style on disclosure, but I would never want coaching. I cannot see the benefit of it at all. I'd spend most of my life coaching people. I'd feel grimy if I started doing that for a living. You know, I wouldn't want people, and you're basically trying to lie. I mean, that's basically the art that you're trying to learn, isn't it? Really, when you know, it might be that you're nervous, but really, aren't you just trying to practice how convincing you are at lying? Which is so I would never coach genuinely, and if the rules changed, I'd just find that difficult. And I don't think they would change because I think people feel like I do. So they just a good night's sleep and tell the truth is all you can do to prepare for trial. Your lawyers, assuming you have them, will be going through the witness statements of the other side, the expert evidence of the other side, finding inconsistencies, finding potentially lies, finding, you know, places to attack and places to advance your case, going through your evidence and your witness statement to find things that are particularly compelling. Judges love contemporaneous notes. So if there's ever a contemporaneous note, I'll be looking out for a contemporaneous note.
Start
There's
writing those
nothing.
notes now is advisable, isn't it?
Well, I do advise people, you know, if something happens, just get a piece of paper, sign it and date it, write down what happened. Judges are much more like, there's one High Court judge, I won't name him actually, he might have been promoted, but he genuinely doesn't trust memory. He just doesn't believe memory. He's like, but no, by the time they get to me, they're utterly convinced of their own case. They practice it over in their heads. They don't know what, you know, and so he trusts contemporaneous notes. It's a very useful tool to have a
Yeah.
contemporaneous note. And
I always love the paper trail, and as I say, I deal with the non litigious side, the commercial side, where hopefully people make more money and just use litigation as a tool to drive them back to that sort of sensible thing. So you've got the trial, you've got the witnesses, they have cross-examination. You must have cross-examined many people. What are your top tips on cross-examination?
I am so my great mentor in life is Lord Wilson of Tredegar, and he's like a gifted fencer with a blade. I'm much more like a teddy bear with a broken bottle behind its back, and I tend to be nice. So it's dangerous because a lot of the people expect Mr. Barrett's getting up to cross-examine me. Their blood is just going, their heart's just rate is just shot through the roof. Okay, they're now it's pounding in their ears, adrenaline's coming through their mouth, and they expect me to attack them. This is the man who's going to attack me. He's going to attack me, and then the minute they go, he's lovely. All of that goes. All of the defenses go. And, you know, and that's a technique. It's a genuine technique, and I like it. It works very well. I remember one of my best cross-examinations ever. I was basically by the end flirting with the lady, and she had completely destroyed her own case. It was, but she seemed happy when she left. I am also nasty at times, so I have had people run out of the witness box crying. I've had senior partner in litigation as a law firm, yell at me across the room. If you think that's how litigation in this city works, then you're a moron. After that happened, they settled at lunchtime for a
Ah, there you go.
large amounts of money.
Well, I always find you're right. It's actually the kindness there because you're a servant to the
It's my
court if you like.
preferred route. I do like it. It works really well. Come, hug me, shiv
Oh
shiv.
yes,
Come,
but,
I'm
but
late.
but it's working on that. So in the same way as I find that humor is very disarming for people, I think people sort of work on that basis. They want to be helpful, and what you're trying to do, as you say, you're piece together, looking for the holes in the evidence and so on and so forth, and they will reveal it. I mean, you can get all sorts of witnesses tied in all sorts of knots, and very easily because they're very nervous normally, aren't they?
They're very nervous. They're very emotional. They also think you care way more than you do. I always think one of the best weapons in a barrister's arsenal is not caring. So there's nothing quite like a witness. Well, like that partner who's just they're ramming themselves at you. They're literally flinging themselves at you. They're angry. And they'll start asking you questions, which is great. I love when that happens. So you just, as a barrister, you don't say anything because the judge will say, "Mr. Baratos, questions, please." Please answer the questions you're asked. Don't ask questions of counsel. And then the judge is angry at them, which is great. Yay! That's what I want to do. And so your own implacability, your own, I'm not rising to this, you can call me anything. It really doesn't matter.
Yeah.
Yes,
So
thank you.
we've read the
Should we move
statements.
on?
They've been cross-examined. The advocates will then give their final closing submissions on the evidence and the law. Talk to me about judgment. What normally happens? How long does it normally take? Why does it seem to take so long before the judge comes back?
Well, there's also written submissions. So don't discount them. A lot of my type of advocacy, the difference between me and a criminal barrister is that we do a lot more written advocacy. So in our skeleton argument that we prepare in advance, the judge reads that, and they'll probably ask for written submissions as well as, or they might have oral submissions as well, or they might, depending on time, just have written submissions. So that is quite an important stage. I think people are shocked by that. It's like, but it is quite useful to put it all in one place. Judges quite like it if it's a Word document and they can cut and paste bits of it. Always be helpful to a judge. Stephen spends an awful lot of time pointing out where everything is in the bundles and putting that in bold. So the judge, my ultimate aim in a trial is to get the judge to be relying on my documents.
Right.
So if my skeleton argument not just is my argument, but is also just quite helpful because he's saying where everything is, then the judge will go back to it more. I want the judge to go look at my papers, not the opposing counsel. That's the ultimate aim, because then I become, much more settled in the judge's mind. It's a real subtle undercurrent trick. So I try and make my documents as helpful as possible to a judge. So then there'll be written submissions. Why does it take so long to get judgment? Well, it takes judges an awfully long time to do things. We've messed up the system. So we've made two classic errors. We've given people their own typewriters and we don't edit them. So for a start, when I started writing for The Spectator, I used to send Fraser 2,500 words and he'd whittle it down to 700.
Right.
I've been edited. I know what it's like. And I thought I was good with the use of language because that's my area of law. Chancery thinks everybody else talks way too much. We think they're waffly. You've never experienced anything. You've been edited by Fraser Nelson, but that doesn't happen with judges. Nobody does that to judges. So in the old days, the law lords shared secretaries, one between, I think, 3 or 4 of them. And the secretary would go, "No, I can't write all that. You shut that. Can you make this shorter? I've got it's to do and it's to do." And and they would, and therefore they would keep it short. And they also, the Victorians knew about this risk. So the Victorians made them read them out loud, which increasingly doesn't happen. But actually, the reason for that was to teach the judge to write shorter judgments. So there's a genuine problem in word processing. And this is a real problem. It needs addressing. Like, we've had judgments that are like 487 pages long. That's a book. Okay, that's not a judgment. It's not a case. And when it comes to teaching the young people law, they have to read all this stuff. Well, the amount of reading is now astronomical. Our lawyers will be less good because they can't do this much reading. Nobody actually reads cases anymore. In the old days, you used to sit down and read the whole case. Even I don't do that now. I just fill it to the relevant paragraphs. Go. Don't need all this nonsense. And the first problem is that we gave them a typewriter and didn't edit them. The second problem is that we adopted this European style of defensiveness in judges. So the judges become very defensive. They don't want any criticism of a judgment. So they put everything in. They put the baby in the bathwater in. It's all there. Everything's there. And it's, they don't want to be criticized for anything. And they want to show that they've shown due regard to both sides and all this nonsense. And you just get rid of it. We don't need that. It doesn't help anybody. Everybody, again, it comes back to that culture of compromise. The theory is that will make losing feel less painful. Absolute nonsense. I don't believe for a second that anybody who's lost a court case goes, "Well, at least the judgment considered my feelings before finding against me for 5 million quid." Just nonsense, utter tosh. So again, it's this culture of kindness, this culture of compromise. It needs to go. Judgments take too long to come because they're too long. They need to be shorter. The Victorians also used to publish them, and the Times used to then demand that they be shorter. You need to get these pressures back. You need
Yeah.
you need the editor of the Times to go, yeah, 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 I'll publish it, but you need to cut that by 1,500 words. You need to get it, and those pressures are necessary to have a quick and effective justice system. And a justice system is only effective if it is quick.
Yeah, absolutely, and seen to be done. And I think that's part of the reason, as you say, that they throw everything into these judgments. Common for the judge to provide a copy of the judgment to the party's legal representatives a day or two before they hand down in open court. Talk to me about the appeal process. What are the grounds for appeal, and what people need to do if they want to appeal the judgment?
Well, we should probably talk about just that because I think that's not going to last. I have a very strong suspicion it's not going to last because what happens in our society is that we're moving away from a real concept of honor. I'm not sure we talk about honor enough. We don't seem to focus on it. We don't seem to teach the young about it. It's not, I've got a child. I've watched a lot of cartoons. It's not in cartoons in the way it was when I was little. When I was little, there was Prince Valiant, and he was off being honourable, a noble knight, and there was D'Artagnan, who was off being honourable, and all of this stuff, and honour was there, and honour was there, and honour is no longer there. And if you get rid of honour, then you end up with only law to regulate your society, which is a very brittle and useless thing. And I'm afraid honour in my profession is fraying. And we've had instances where we had a very famous instance because he was prosecuted for it, but where a barrister, because he was so passionate about, or because he cared so much about the politics of the case, leaked the judgment in advance, which is outrageous. That's dishonourable. I mean, it's just horrendous. And as a result of this, and then there were other mutterings and instances and things around the edges. I'm not sure how long getting a copy of the judgment in advance is going to exist. The other type of bad behavior I've seen in a very, very, because it was a case over colossal sums of money, is I've seen the other side then try and argue with the judge to carry on the litigation once the judgment has come. And you see this with orders as well. When an order comes from the judge will have you look at it for typos, or if you to do two things: look at it for typos, so the judge doesn't have a typo in and look silly. Two, is it actually what the judge said in court? So the judge will say their order, and the order exists from when they say it. And barristers dutifully note it down, or solicitors behind you note it down. Everybody notes it down. And then the judge goes away and it gets typed up, and then it gets sent to you. And you're supposed to check it for typos and check that he's actually he or she's put everything in that they said it would put in, hasn't done the opposite of what they said they were going to do, basic stuff. But that too has become a battleground now. And I really hate it because, again, I think it's dishonorable. The battle is over. The battle was either won or lost. The result was the order. You cannot refight this. And it's particularly prevalent. I've noticed it in the family division a lot. And the tendency to fight is that's very reminiscent of divorcing couples. I mean, that is, that's all the emotion and the whatever. But it's also now in commercial cases. And commercial people are behaving in a way that we did not used to behave. And I will get very snooty about it. So I was in a case where there were 17 silks, 17 QCs, and me. I was the only non-silk. And I told the others off, literally by a mass email, saying this is I consider this inappropriate behavior. If it continues, I will bring it up to the judge. Because we were arguing, relitigating between ourselves as though we had the power to remake the order, which we do not have. I'm a constitutional nerd, so these things really matter to me. It's like, it's wrong. It really gets my goat. It's also immoral, it's also dishonest, but it's just constitutionally wrong. The order has been made.
Yeah, but it's human nature, isn't it? I mean, you do wonder why on earth they give them it in advance, so they're sort of prepared. I mean, they do this in politics as well. But you're right; it's either going to be leaked or they're going to try and re-argue it. But yes, it's something
I
to look
think it
at for
will
the future.
stop. Yeah.
Yeah, for those very reasons. So talk to me then. You've got the judgment. You don't like it. In spite of the fact you've got it early and you might still want to argue it. What are your grounds for appeal? Talk me through those.
Well, the most important thing that people forget is that you can't reopen facts. So when I talked about the judge being in charge of fact, it is very important. So if the judge finds as fact that you're a liar, you cannot appeal and say, I'm not a liar. I'm sorry, High Court judge says you're a liar. And that's why that's really, really quite damning and important. And there was a British member of Parliament who a judge said that about. And I was just like, that's it. That's over. There's nothing you can do. There's nothing. That's it. You are now a liar. In fact, you can relitigate facts if new evidence comes to light, but it has to have been hidden. So you can't just have been lazy. You can't just have been incompetent or just if you knew about it but didn't put it in the bundle, then no. But unless something brand new or was hidden comes to light, you're not going to be arguing facts. What the judge found as fact will be taken as fact by the Court of Appeal. The Court of Appeal really is looking for errors of law. And that's what they want to do and make out. Is there an error of law that has been made? Has somebody applied something, in a wrong way, which does happen. And then you have the Supreme Court look at exactly the same thing. And the idea is to have these layers of judiciary because mistakes do happen. And, we really, the one difference judges say when they move up to the Court of Appeal is how they feel the burden of case law now. It's like, yes, when I was doing a trial, it mattered. And obviously it could be, any judgment could become a leading case. But if you're in the Court of Appeal, you know that it's almost certainly a leading case by definition now. And therefore it's going to have potential ramification throughout potentially hundreds of years. So, you really are trying to think on a meta position of if I do this outcome, how will that replicate in future? Because as I've tried to explain to people, good law is a rule known in advance, which is applied consistently. And
Yes.
the judges, the Court of Appeal judges in particular, really, and then obviously the Supreme Court, takes it up to a meta level. But that they really are thinking about that. There's going to be consistent application of this. What bad things are going to happen as a result? What good things are going to happen? What am I missing? Why has this not happened before? It's really very, very meta, and they'll think through a lot of points. And there's a lot of chatting about abstract that goes on. They don't disclose the case. They're still the best judges in the world and have the deepest respect for them, but they become very academic around the Court of Appeal level.
Yeah.
That my dad is a legal academic, and he tends to hang out more with the senior judges because they tend to be much more academically minded. Our current president of the Supreme Court would have, had he become an academic, would be a leading academic.
Right.
He's a brilliant, brilliant mind. And one of the other Supreme Court justices was a leading academic at Oxford. He taught me contract law. So he is just and I hate saying, as you well know, and I'm sure you hate it too. I hate admitting when lawyers are really clever and good, but Lord Burrows and Lord Reid are geniuses.
Yeah.
Doesn't mean I agree with them all the time.
Yeah, and I think that's the really important point. So there's in summary, it's sort of not it can't appeal on the facts unless there's new compelling evidence which you should have basically you haven't hidden. It is totally new, and there's no excuse for not having brought it before the courts beforehand. But it really has to be a point of law, and those are going to be fewer and further between by the sounds of it. Finally, just in a couple of sentences, then talk to me about enforcement.
So enforcement is really something that barristers never or hardly ever get involved in. Um, I think there are bailiffs. There are a range of options in the procedural rules that courts have. So somebody was doing something. Somebody was going to get called. They can judges at the end of the day they can imprison people, but they can drag you to court. They can garnish your salary. They can take your earnings at source if you've got an employer. They can order your employer to pay money in things if you're not doing things properly. They can charge you interest rates. They can effectively really duff you up. They can seize any property that you've got. They can order houses sold that are in your name. They can really go into getting the money back. And that's the other enforcement's a hugely important area of law. And I shouldn't diminish it in any way because again, it's a vital part of keeping the system going. Because if you had a system whereby judges were making all these orders, but they never actually got carried out, you'd be a pretty broken society.
Well,
So
no, it's got to be right. You having spent all these huge amounts of money in court for it not to be able to be enforced would be an absolute nonsense, wouldn't it?
yes, it would. And so it is taken very seriously. And we enforce globally. I mean, the one aspect of enforcement that I do is I apply for and fight against getting foreign court judgments registered here. Because if they're registered here, then they can then be enforced here. And then that's a problem or a good thing, depending on
We're
which.
going to unpack that in a bigger way.
Okay.
But a top tip for avoiding foreign judgments being enforced over here. What do you do?
Uh, uh, be careful where you do business is, I think, a top tip. but international business people, in my experience, are quite savvy. But and the courts are better at it. What you don't want, though, God, so during Brexit, the international public lawyers were getting all upset and going on and on about because we would lose. That there was a system in the EU for automatic recognition of judgments, and I'm afraid, I hold the international public lawyers in very little, with very little respect. But the idiots were trying to get us into an automatic system. You don't want automatic systems of recognition. There are EU member states, which I won't name them because it's not political, but who are dodgy. And you could get a dodgy judgment, and then that's automatically enforceable in London. No, this is a really bad system. So I was actually asked I was asked my view. Lots of us were asked our view on this by the Lord Chancellor's office, by the MOJ, and I'm just like, no, 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 no. Should we try? Should we make trade concessions to get into this? No, definitely not. Don't let the idiot politicians have automatic recognition of judgments. I mean, it genuinely is probably the stupidest thing that a politician can do. They go to a lovely dinner, they get to see, a foreign country, they get to feel like a dignity and a statesman and all the rest of it, and then we get stupid, judgments coming through automatically. No, it's a really bad idea. Automatic recognition of judgments is a very, very bad.
Avoid it like the plague. Avoid litigation like the plague, as I said at the very beginning, if you can. A few amazing tips on that. But if you're unfortunate enough to do that, well, we thank you very much, Stephen Barrett. Very good for taking us through all of those. We'll be back with a pair of briefs. If there are particular issues you'd like us to unpack, do get in touch with me at Andrew Eborn at Octopus TV, and I'll bring Stephen in as well. So on the usual sort of social media, do subscribe, press that button now for more of the same. But for now, Stephen Barrett, thank you very much for joining me.
Thank you. It's a pleasure.